Well, thank you so much. I am here to talk about immigration issues for new arrivals in Colorado, which I imagine is very relevant for most of you. We can go to the next slide. Uh, so what I thought I would talk about is just generally current trends in Colorado, who we are, right? Who is Rocky Mountain Immigrant Advocacy Network, or REMAIN, what we can offer immigrants, and then kind of talk a little bit about some common pathways towards lawful immigration status for new arrivals, mostly families, and certainly types of relief that we at REMAIN are frequently involved in. And we can certainly ask, you can ask any questions at the end, or if there's a burning question about something that I said on any slides, please definitely feel free to raise your hand or signify somehow that you have a question. You can probably put it in the chat too. We can go to the next slide. Okay. Who is REMAIN? REMAIN is a nonprofit organization that serves low-income men, women, and children in immigration proceedings. I'm not going to just continue to read the slide, but we promote sort of information sharing, right? That was one of our original purposes, was to make sure that people had information, legal information regarding their rights and relief available to them and services that were available across the state. Next slide, please. Okay, so I think I'm using current trends at the Denver Immigration Court because those are sort of numbers that I have access to, but they sort of reflect the sort of numbers generally that we've seen in Colorado. As of May of 2024, there were 75,693 cases before the Denver Immigration Court. For perspective, I put some historical numbers, and at the end of the fiscal year of 2023, which ends in September of 2023, there were 46,888 individuals, and then even fewer as of September of 2022. So you can see just like the enormous increase in the number of people who have come to our state and just generally have come to the United States. The top 5 countries people are coming from are Venezuela, Colombia, Mexico, Nicaragua, and Peru. We've seen an increase in people coming from Ecuador as well. And there were sort of waves of people coming from Haiti and Cuba, but by far the greatest numbers are from Venezuela. Next slide, please. And we are seeing many families that are coming, and we're seeing families sort of in kind of a traditional concept of family, but also in the sort of non-traditional makeup of family, and which is a little bit hard to identify. And sometimes that means that people are separated at the border, in terms of separated from their family members that they have entered with, or that they came to the United States with. And I wanted to sort of review a little bit, because it's so important when people arrive here and they have had any interaction with immigration, that they are aware of the requirements placed on them, because sort of ICE and Customs and Border Protection don't do a particularly good job of articulating to individuals what their requirements are, what their responsibilities are in their native language. It's important to understand like the different procedural postures that people can be in. So one of the ways that people enter and the procedural posture that they're in is that they might be issued what's called parole. And one of the initiatives that this administration put forward was the CBP1 app, or the Customs and Border Protection application, where you can use an app on your phone or on an iPad in Mexico to request an appointment with CBP officers at one of the ports of entry to be processed and allowed to come in to seek asylum before before any immigration court in the nation, but our context is the Denver Immigration Court. There are also, although right now it's paused due to the new policy, there are people who are apprehended after attempting to enter unlawfully. They're then processed and released and then placed before the Denver Immigration Court. So they certainly will not have had a parole that is issued by officers after requesting an appointment. They might have a parole that was issued after the fact for whatever reason. It might be that they have some kind of medical concern, or they might be granted a parole to release them into the United States. Then there are people who were never apprehended. So they never had any interaction with immigration. They might not have presented at a port of entry. They might not have been apprehended when they tried to cross, or when they successfully crossed unlawfully, and they had no contact with immigration. So they're not in the system at all. Then we also see people who are in what's called the Family Expedited Removal Management Program, which is a really long, immigration likes to use really long terms and then reduce them to acronyms. But traditionally, where someone has entered unlawfully, so they crossed a river or they crossed a desert, those individuals are going to receive, those people are going to receive a removal order. So they are not allowed to see a judge generally if they have entered unlawfully. However, if they express a fear of return to their home country, then they're entitled to what's called a credible fear interview, which basically is an interview with an asylum officer to determine that there's a chance that they could win an asylum claim in the future. If they're found to have a credible fear, then they are then processed in one of the other ways. They might be paroled, they might be released on their own recognizance into the United States and are allowed to proceed with their asylum proceedings in immigration court. Traditionally, this was always held in detention right at the border, right? So it was like the minute they were apprehended, they were held, they were detained for a while, and received a credible fear interview by phone while they were detained at a detention facility somewhere at the border, or perhaps on the interior, but generally at the border. The Family Expedited Removal Management Program selected families as a group that could be placed in a pilot program, or it's no longer pilot, but it was a pilot program for a while, of allowing people to enter the United States and be released, but then have their credible fear somewhere on the interior, with the justification being that then there would be more resources for more legal resources. I can certainly answer more questions about it if there are any, but it's moving on a really, really expedited timeline, and there is really no access to counsel. And so people are often living in shelter, and so they don't have access to food, let alone an attorney. So if someone encounters someone in the Family Expedited Removal Management Program in one of your programs, please reach out to us. My phone number is at the end of this presentation, which can be shared, and then I will also be sharing the flyer that people can use. And then there are also unaccompanied minors, right? So generally, where a child enters the border, or is encountered at the border who's under the age of 18, does not have a legal guardian immediately available to take care of that child, they will be processed as an unaccompanied minor through the Office of Refugee Resettlement, which is essentially the federal version of the Department of Human Services. And this is going to be true even if they arrived, right, with a grandparent or an aunt or uncle who might have a biological connection to them, but has no legal authority to care for that child. So they are going to be separated from those family members and processed through the Office of Refugee Resettlement, unless there's a legal document that shows that that family member has the authority to care for that child. Okay, next slide, please. Okay, so a little bit of context on our programs. We started as a program to serve those detained adults detained in the immigration facility in Aurora. So we still don't detain families in Colorado. It's just single adults that are detained at the detention facility in Aurora. But we sort of expanded to a children's program when we started getting phone calls from across the state at a time when juveniles were being held in state facilities on ICE holds. That's no longer the case, but ICE was basically calling juvenile facilities and inquiring about undocumented juveniles with a delinquency history, and asking the facilities to hold them and asking them to allow them to interview the children. And so we started getting phone calls basically saying, like, we need help, we don't know what to do. My child's in juvenile detention. And then they said that ICE is going to interview them. And so through one fellowship, one of our lawyers who's no longer with our organization started the children's program. And then right when that happened, the policy changed and they were no longer allowing ICE to access juveniles in the state system. But so we shifted and started a program that was serving immigrant youth and families who suffered abuse, abandonment, neglect, trafficking, or other crime, with case screenings and assessments, direct legal representation, referral to pro bono, a network of pro bono attorneys across the state, as well as education and outreach like this presentation. Then we added our social service project that provides wraparound services for people who are in detention and also to children and family survivors of crime. And we have our anti-human trafficking project that's led by Caleb Stewart, who's one of the leading anti-trafficking experts in the state. He serves on the state councils, and he does a lot of work with immigrant trafficking issues. And then we have a sort of sub-program of the children's program, which is the Immigration Court Help Desk program, which is the program that I run. And it's basically pro se support, or support for those who don't have lawyers. Basically, we run a hotline and have a presence at the Denver Immigration Court, where we are able to answer questions and review paperwork for people so that they understand, like, what procedure they might be in and what their next steps are, right? And even try to assess whether or not they have relief available to them. Okay, next slide. Okay, before I get into the pathways for immigration status, I do want to talk a little bit about the fact that, those who have encountered immigration, those who have had some interaction with immigration officers, be it Customs and Border Protection or an ICE officer, will likely have paperwork that will demonstrate whether or not they are in removal proceedings, or whether they need to present for what are called check-ins at the ICE office in Centennial. And it's all in English. It's all clear as mud, I would say, as to what people are required to do. And so when you are working with someone who is undocumented and who is clearly a recent arrival, it's really important to make sure that if they do have paperwork, they have it somewhere safe and they are making sure that it's being maintained in a safe location, and B, make sure that they understand what their responsibilities are. And if not, then connect them. Like I said, I will share our flyer, but connect them with our hotline to where we can answer questions, and we can even, in reviewing photos of them, like, let them know whether or not they need to report for an ICE check-in. It's also complicated because a number of people outside of those that are set before the Denver Immigration Court, a lot of people may still be set in Texas, Arizona, or in another state where they went to first. And there are all kinds of requirements regarding how they change their venue to Denver now that they want to live here. And if they do make a misstep, then they can be subject to, it's unlikely in family cases where the entire family is here undocumented, but with single adult cases, they may be subject to being redetained if they make one misstep in terms of how they ask to have their case moved to Colorado. So that's just another reminder to please have people consult with an immigration attorney. It doesn't have to be us, but we do provide a free hotline where we can help people assess their paperwork. I will also pause and see whether there are any questions about the population generally, how people get here, or like the procedural postures before I go into what they might be able to do with their case.
I'm assuming you guys have translators for the languages, is that right?
Yes, in order to work at Remain, you have to be able to speak Spanish. So the vast majority of people, we don't need to use an interpretation service, but we do have interpreters. We do have an interpreter line that we use for other languages, and other dialects, from countries like Guatemala and Mexico that might have, more indigenous languages that are their primary language, along with countries from around the world. And the court is required to provide interpretation in the language, that the individual, understands best. I'm not seeing any other raised hands, so perhaps I will continue. Okay, so common pathways towards immigration status. I always have to put this little disclaimer at the end saying that this is just immigration, and this is just immigration law information. It is not a consultation, nor is it advice for any particular individual, because it is very, very complicated. And this is not an exhaustive list of the relief that's available to people, but it is the most common, these are the most common forms of relief that are available to people who are recently arrived. So I'll kind of go through those. Next slide, please. Okay. Asylum is by far the most common form of relief that individuals are seeking if they are a recent arrival. And it's a form of immigration relief available to people who are unable to return to their home country because their government is unable or unwilling to protect them from past persecution or a well-founded fear of future persecution. Of course, that could be because they are in fact the persecutors. But they have to show that the persecution is account of their race, religion, nationality, membership in a particular social group, or their political opinion. And typically, the applicant must file within 1 year of entering the United States. So all of these recent arrivals, one of the biggest issues we see is that due to so many people being scheduled before the immigration court, many people are not getting their first hearing before that 1 year filing deadline. And while they are able to file their asylum application with the court at any time at the filing window, they don't actually get that information. And so what we're finding is a lot of people come at their first hearing and they weren't ever told about the 1 year filing deadline, because while the officers are at the border are required to tell them that, it's not happening for various reasons. And so that's one of the reasons that I present during outreach presentations about this issue, because I want to make sure that people know that. For family cases, one of the good things is that where there is a nuclear family where there are two individuals who are married and they have children, one of those adults can apply for asylum, and the others can be included as derivatives. Unfortunately, a child cannot provide asylum protection derivatively for their parent, so it has to be a parent providing protection for a child. But in that situation, you can have parents and children receive asylum all together based on one application. This includes stepchildren, so it doesn't have to be biological children. It can include stepchildren and adopted children. Next slide, please. Okay, another unfortunate trend that we're seeing is that there are a lot of new arrivals who are eligible for what's called U visa protection for survivors of serious crimes. And I use survivors and victim both on the term survivor and victim on this slide, both because I have found that my clients identify one way or another, right? They might believe that they are a survivor of the crime, they have survived the crime, they're on the other side. And some of my clients still feel very much victimized by what happened. And so they still want to be identified as a victim because they feel that they need justice. So I use both terms, and I let my clients guide me in what term I use when referring to their cases, but also I use both terms because the statute actually refers to victim. And so I am using the term victim because of the statute. So in order to qualify for a U visa, someone has to show that they have been the victim of a qualifying crime, and that's usually a felony level crime, except for domestic violence and sexual assault. They can be misdemeanor level crimes, and they are almost all crimes against the person. So they're not crimes against property, they are against the person. So that, because the idea is that it's a serious crime against that person. In order to qualify, you can be an indirect victim. So you don't actually have to be the one to have suffered the crime if, for example, you are the parent of a US citizen child victim. And there's specific language in the statute that allows for that. They have to have reported the crime. So as I'm sure you all know, sometimes that can be a difficult prong for this type of relief, because there are many reasons why crimes are not reported. I just recently had the experience of finding out that my client's domestic violence incident was not recorded, even though the police did respond, and a neighboring jurisdiction had actually taken a short report and transferred it to another jurisdiction. But it might also be that the survivor didn't report the crime because of fear of the fact that they were undocumented. So this is sort of a complicated form of relief, and it actually was born out of the idea that we want those who are undocumented to come forward and report crimes, because those who commit crimes do not just commit crimes against undocumented individuals, they also commit crimes against citizens. And so this is a way to have the most data points possible in order to combat crime. One of the requirements is that they cooperate with law enforcement. So not only does the crime have to be reported, but then they have to continue to be willing to cooperate with law enforcement in the investigation and prosecution of the crime. That doesn't mean that if, like, for whatever reason the report goes nowhere, that person doesn't continue to be eligible for relief. It just means that they have to never at any time just fail to cooperate, fail to answer the phone, or not respond, not call the officers back, or refuse to cooperate. They also have to show that they suffered substantial physical or emotional harm as a result of that crime. The key is reporting the crime, cooperating, and not the status of the perpetrator or the relationship between the perpetrator and the victim. So it can be stranger violence. Unlike some of the relief we'll talk about on another slide, where the relationship between the victim and the perpetrator is important. A U visa comes with 4 years of permission to be in the United States, as well as work authorization. And then after 3 years, that individual can apply to become a lawful permanent resident of the United States. The rub with a U visa is that there are only 10,000 visas available each year. That doesn't mean that if they get to the 10,000, everybody else is out of luck. It just means that there's a wait list that is getting ever longer. So the last time I checked, there were over 170,000 applications pending. So that shows that at this point, it's probably upwards of 20 years before someone might get a U visa if they apply today. There are mechanisms in place to protect people who have an application pending, and also to provide for work authorization after a few years of having a pending application, but it is going to take a very, very long time in order to have a U visa approved. Next slide, please. I also wanted to talk about T visas for victims of trafficking. So oftentimes when I mention human trafficking or trafficking, people think of much more organized sort of forms of trafficking, or what's on TV, like during the Super Bowl, there are like the commercials and the posters about the girls being brought in during the game and that kind of thing. And that absolutely is trafficking, but that's not the only example of trafficking. And unfortunately, with all the new arrivals coming and with people having very few resources, we're seeing an uptick in the number of trafficking cases being reported to our organization. So under immigration law, in order to qualify for a T visa, they have to show that they are the victim of a severe form of sex or labor trafficking. So that's commercial sex, which many people think of that as an exchange of sex for money. But in actual fact, the definition is exchange of sexual acts for something of value. And that something of value can be something other than paper money. It can be goods, it can be property. It could also be the promise to refrain from doing something harmful. So the context that we see this in is, unfortunately, people might have had an agreement with someone that if they make it to the United States, they could live with that person and be protected by that person, and everything would be fine. But then when they get here, that agreement changes and there's a debt that they have to pay off, or they are forced to have sex with a person in the home in exchange for that person not calling immigration and quote unquote having them deported. That's not possible legally. That person can't just call and have ICE come get someone here because they're undocumented, but they don't know that. And so forcing them to have sex in exchange for a promise not to call immigration, or a promise not to put them out on the street, is absolutely a form of commercial sex, and therefore a severe form of sex trafficking, and might make them eligible for a T visa. In the labor context, we often hear people think of it as kind of more organized labor. It might be like even in a roofing company, or a ranch, somewhere on a ranch, or in drug trafficking, that type of thing. And those things still absolutely are happening, but it can also be labor or services like in a home. So again, we're seeing people who had an agreement with another like family friend or member of their family even, that if they made it to the United States, that they could live with them, they would find them a job, they would, let their kids go to school, everything would be fine. But when they get here, again, that agreement changes. And now the wife of the family is doing all the cooking, the cleaning, and caring for the children with no compensation. They're not even allowed to sit and eat dinner with the other family. They call her a slave, and then the perhaps, let's say there's a male partner in the recent arrival family, and that male partner is found a job at the same roofing company that the family friend works at, and every time they get paid as they leave the job site, there's an immediate demand for their paycheck, and it's to pay a debt of living with them, or perhaps they lent them the money for their trip. And it's all done under threats of calling immigration, saying, I signed sponsorship paperwork for you, I could call immigration and have you deported. That is also trafficking, and might also make the family eligible for a T visa for victims of trafficking. They have to show that they're physically present in the US on account of that trafficking. And again, it doesn't have to be that, sort of this traditional view of a trafficking ring where they brought them over in shipping containers, or they organized their trip or what have you. It can also just be that they're physically present, that they couldn't leave their trafficking situation in the United States, or that they are here in the United States seeking sort of therapeutic services or seeking justice for their trafficking. You have to make some connection to the United States. And they have to show that they have complied with any reasonable request for assistance in the investigation or prosecution of the trafficking, because they have to have reported it to some law enforcement agency. That definition, law enforcement agency in this context, is very, very broad. So it could be a number of agencies. And where the primary victim is under the age of 18, they are not required to make a report. And so there's that prong doesn't exist for child victims. And then they have to show that they would suffer extreme hardship involving unusual and severe harm in the event of removal. So that's usually showing the conditions in the home country that brought them here, and then also showing that it meant that they became vulnerable to a human trafficking situation. A T visa, again, comes with 4 years of permission to live here and a work permit, and after 3 years, the right to apply for residency. The waitlist is not as long for this one, thankfully, although it is growing because it is also subject to caps. But they also are able to waive certain immigration violations in connection with their application. I'm gonna pause for a second and see if there's any questions about any of those forms of relief or human trafficking amongst new arrival populations. No. Okay, well, we can move on to the next slide. Another form of relief that's available to people is special immigrant juvenile status, and it's available to young people under the age of 21. And I say this is one of my favorite forms of relief, not because of the sort of subject matter of the relief, but rather because it doesn't require very much repetition of someone's experience to immigration officers, which with asylum and U's and T's, there's a lot that people have to reveal and talk about with immigration officers or reveal to immigration officers that can feel very invasive versus with special immigrant juvenile status, it's very limited. It's a pathway to permanent residence for a child who's under the age of 21 and unmarried. They have to be under the jurisdiction of a juvenile court, and that can be probate in proceedings for guardianship, domestic relations in custody or allocation of parental responsibilities proceedings, dependency and neglect. So where the state has actually filed a petition to protect a child, delinquency and adoption. That child then shows that to the judge, to the court, that they cannot reunite with one or both of their parents due to parental abuse, abandonment, or neglect under Colorado law, and show that it's not in the child's best interest to return to their country of origin. Once they have that order from the state court, they can apply for the visa with immigration, and once they have the visa approved, they might be eligible for a work authorization. And then at this point, what it's looking like 5 years based off backlogs in the number of visas available to juveniles, they can apply for their lawful permanent residency and then eventually become U.S. citizens of the United States, U.S. citizens. Yeah, so this is I think the reason this form of relief is so helpful for juveniles is that it acknowledges that child welfare issues should be designated to the states, and that state courts do deal with it all the time, versus federal immigration officers should not be deciding where a child should live or what is in the child's best interest. And so once the state court has finished their part of assessing the best interest of the child and assessing whether there's parental abuse, abandonment, or neglect under Colorado law, and there's an order issued, immigration really does not have much authority to question that order or question that the child might be eligible. Okay, here's a question to verify: is the one or both parents to be read as one only if there's one parent involved? Both isn't a fitting term. So it could be that like there are where there is one parent who is an offending parent. And so it could be that like the mom is petitioning for full custody because dad abandoned the child or was abusive to both of them. But it could also be where both parents are abusive, have abandoned the child or are neglectful. The reason we are very clear about this in our presentations is because the statute used to only applied to kids who were in sort of foster care or who had no parent available to them. And so then the statute changed to include cases where it was only one parent who had abused, abandoned, or neglected both children, or had the children. Any other questions about special immigrant juvenile status? Or any of the other forms of relief if you've thought of it just now? No. Okay, then I think we can go to the next slide. This happens less frequently, although I think it is still a valid form or a form of relief that people should be aware of. So generally, you know, when I think sometimes people think about like US citizens, you know, getting married for and being able to provide papers for their spouse or partner. And that certainly is true, and that is certainly a way that people can get status. But it creates an inherent power imbalance because where a US citizen or lawful permanent resident is applying for their child or spouse, they are the ones who have to submit all the paperwork. The intending immigrant has absolutely no power in that situation. They cannot affirmatively apply for immigration status. And so in the context of domestic violence, that created this like extra layer of power imbalance. And so Congress decided to create a mechanism by which someone who is in an abusive relationship, whether it's a parental relationship or a intimate relationship, a spouse, that they have a way to apply for status without needing the help of the abusive family member. And while it is called Violence Against Women Act protection, it does not only apply to women. It does acknowledge that men are also survivors of domestic violence and can also be placed in this power imbalance. So it's a pathway to lawful permanent residence for victims of domestic or family violence. They have to be the spouse, parent, or child of an abusive US citizen or lawful permanent resident. And the immigration status of the abuser and the relationship are key in this. So unlike the U visa, where you could have a domestic violence situation where it's two undocumented people involved, in this situation for Violence Against Women Act, the perpetrator has to have either US citizenship or lawful permanent residence. It does not matter, however, if the violence was ever reported. So in this context, in the Violence Against Women Act context, they don't have to have made a report with the police, and they do not have to continue with an investigation or prosecution of the crime. It certainly helps if there is a police report that you can point to regarding the violence, but it's not required. What they are required to show is proof of their abuser's immigration status, proof that it was a good faith marriage, which means it was not for immigration purposes. This also includes kind of non or versions of marriage that are not culturally recognized in the United States generally. So organized marriage is not something that most Americans engage in or believe in. But if it is an organized marriage and the two parties actually had never met until their wedding day, that is also a good faith marriage. It just means that it's not for immigration purposes. So it's not like the movie Green Card or some of these movies, oh, The Proposal, for example, where, you know, a US citizen is like, hey, I've got status, you need status, let's get married and we'll get you status. That is not a good faith marriage, but it doesn't have to be a Hallmark movie of like, we've been in love for years and years and years. That's not required. They have to show proof of the relationship. So they have to show some proof of the marriage, official marriage, that was valid where it was celebrated, and show that it's not for immigration purposes. They have to show some joint residence at some point. And this is not defined. So there isn't really a like, oh, you have to have been living together for more than 1 week or something like that. It can be a couple of days. You just have to show that there was joint residence at some point. And one of the contexts that this happens in, right, is the context of organized marriage, where you have someone who might, you know, be a lawful permanent resident. They go back to their home country. Their parents organize a marriage with someone from their home country. They have this wonderful wedding. It's beautiful. It's amazing. And then they get to the United States, and like 2 days in, the situation changes, and now there's violence or there's cruelty, and that the intending immigrant has to flee the situation. It can be a matter of days. They also have to show battery or extreme cruelty. So physical abuse is not the only form of cruelty that applies in this situation. It can be other power and control kind of cruelty. There's actually a case that provides precedent that states that even just a threat to not apply for immigration relief can be considered extreme cruelty. So it can be threats, it can be verbal abuse, it can be emotional abuse, it can be economic abuse. It does not have to be physical abuse to count for extreme cruelty. And the intending immigrant has to show good moral character. So that what that means is that they have to show that they don't have certain criminal history in their history. This form of relief applies to all marriages that are valid where celebrated. So this applies to gay marriage. It applies to marriage between men and women. It applies equally to men and women in terms of being able to show that they were the victims of domestic violence. Any questions on VAWA relief? Nope. Okay, well, I've gotten to the end of my slides, and I'm happy to be open to questions on anything that I spoke about, but also if you have questions that you don't think I addressed, I can try to answer the question. Like I said, immigration law is very, very complicated, so there might be something where like, I don't actually know the answer to that. Am I better than I thought?
I have a question.
Sure.
When you were talking in the section about unaccompanied minors, you had mentioned some paperwork or documentation related to having legal authority to care for a child. You
Yes.
mentioned that sometimes that was lacking when it's like a grandparent and a child or what have you, but is that something that's required in general? Like when someone encounters Homeland Security or whatever with any child, do they have to show some sort of proof that they're related and legally authorized to be in their care?
I think where there's a question, then it absolutely becomes required. I think like where a mom and 2 kids show up at the border and the officers interview them and they turn to the kid and go, who is this person? And they say, that's my mom. They're going to let the family pass altogether. But where, you know, they show up and the kid's like, oh, that's my grandmother or that's my uncle, they are going to need paperwork that shows that they are that they have legal authority from a court to make decisions on behalf of that child. And this is a very complicated policy, right? Because on the one hand, you absolutely do not want children being ripped away from the only people that they know in that situation, right? And being placed with immigration officers and being placed in the Office of Refugee Resettlement through a shelter system that is by all accounts has far fewer abuses than it ever did, but it's still a shelter system. It's still like not with your family, but at the same time, we do unfortunately encounter situations where people borrow a kid from another family member or from friends in order to try and cross because single adults are subject to higher rates of removal orders if they don't have a child with them, right? They might allow people to enter with a child more frequently. So I think the problem is that, and I'm seeing a question in the chat of whether or not there's a list of approved types of documentation. There's no list that I know of that's actually outlined, but I think the types of documentation that we've seen where kids have not been removed are things like court orders. Some countries have kind of like a division of family, division of the family or division of family issues where there's sort of like almost like a magistrate or a like lead attorney who's able to make custody determinations, that type of paperwork. I have seen cases where if they had the death certificate of both parents, and then they have birth certificates that do a chain of relationship that show that the person that they're entering with is their grandparent. I have seen that work because it's like, well, most countries where both parents are dead, what's it gonna default to? It's gonna default to the grandparent. Yeah, so those are the types of examples. But the truth is that like, while they are separated, as long as those family members are able to pass through immigration independently, they can then apply after the fact to have the child released to them by showing that there is a relationship, and then they are assessed kind of the way you would do a home study in a state dependency and neglect proceeding. They are assessed and the child can be released to them that way. Yeah, so that's the unaccompanied child situation. Any other questions?
Well, I guess I'll ask a follow-up question in that case, since I'm hearing silence. There's somewhat of a fear in our family shelter system, not just with this population, but just in general around trafficking of minors, as you know. And I know that's something that Remain supports on, and you have the anti-trafficking program. I'm wondering if you're able to share like any tips or like things that major red flags to look out for, so folks feel a little more comfortable in general around this.
Yeah, absolutely. So assessments for trafficking are always hard, right? Because we see a lot of non-traditional situations. We see a lot of situations where children might be younger than we would find acceptable, working alongside family members or friends of family, because that's just sort of something that happens in their home country, right? Like I regularly talk to young people about their cases. That's like primarily who I represent is children. And most of them report working from a young age, whether it's like 8 or 9 or 12 or 14. They work alongside their parents and they work really, really hard. And um it breaks my heart to hear that, right? Breaks my heart to hear about children who are working in dangerous conditions from a very young age, but it doesn't actually make it trafficking, because it's missing that coercion, fraud, or force element. So what I look for is, when I'm like, I think I need to talk to this kid a little bit more. I need to talk to this grown up or this adult more, is I look for what happens to the money when they earn it, right? Like, so do you control the money? Who controls the money that you are paid? How are you paid? How much are you paid? Are you even paid? Then I look at what's being said at the time that the agreement for work is being solidified, right? Like, what is the agreement, and has the agreement stayed the same? Um, do they feel like, I ask questions like, well, if you wanted to take a different job, like let's say you got offered an even better job making, I usually up it by like $10 an hour. Like, let's say you could make $10 an hour more, like what would happen if you told this person that you couldn't work for them anymore? What would happen if you objected to any of the conditions that you were working in? I also, like, when it comes to children, I also look at like who has control over their documents and whether or not they at any time can have access to those documents. And that's true with adults too. And then I also listen to like how people present it. Like, do they feel like they don't have another choice? Because it might be that they are making the choice that they have, right? There are many people who are doing work and living in situations that are not ideal, but it's the choice that they have and they are actively making that choice. But then there are choices that people make. They might have initially made that choice voluntarily, but then are stuck in that choice because of the force, fraud, or coercion. And the choice might not be what they originally thought it was going to be. So these are the types of things I look at. For example, I won't identify the shelter, but I am trying to screen a young person who the shelter staff have been trying to schedule me a consultation with these young people. And every time they talk to them about it, they're super excited. They're very happy about the fact that I might even be able to help them apply for a work permit. But every time we actually have something scheduled, this kind of strange friend who has no actual relationship to them has organized something else for them to do. And so is engaging in an obstructionist behavior in terms of them being able to have a consultation with me. It might mean nothing, right? It might be a total coincidence. It might be that this person thinks that they know better and thinks that they, are going to get them services somewhere else. But it also may be that he's actively trying to prevent them from telling me something. So these are all examples of situations that merely mean that someone needs a screening, right? It doesn't mean, oh my gosh, it's a trafficking situation, we need to intervene. And even if it is, I will caution you against doing anything without the permission of the person who's in the situation, because they are in the best position to make a decision as to whether or not it's safe for them to try to escape or try to report something. It can actually put them in way more danger if we do something too early or too soon or without a solid plan.
Thank you.
Mm-hmm. Well, and I also I work with a lot of teenage boys where I'm like, don't you want to go to school? Let's go to school. Let's go to school. And they're like, no, I want to work. I need to work. I need to work to send money home to my family. And I have to pay, you know, for my trip. And that does mean that then I ask more questions about like why they have to pay for their trip and what have you, but it also could just mean that they are 17 and desperate to help their family, because their family is struggling in home country. Any other questions? Well, like I said, people are absolutely welcome to email me or call me. If I don't respond quickly, Rosie knows this, just ping me, just send me another email. I just like, we are dealing with unprecedented numbers of people and we're trying to get to as many people as we can. So my inbox kind of gets a little full. But I will also send a flyer for our hotline where so that it's spreading the wealth of questions to my colleagues. They don't know it yet, but they'll be fine.
Great. Thank you so much, Emily. That was wonderful. Very helpful
Thank you,
presentation.
Emily.